Well, good evening to everyone, or good morning if you're in Geneva, like Yuan is at the moment. And thank you very much for joining us for this webinar on overcoming intellectual property barriers to equitable access to medicines for pandemics. And tonight we're joined by Dr. Yuan Qiong from Médecins Sans Frontières, or Doctors Without Borders, and by Dr. Patricia Ranald from AFTINET, the Australian Fair Trade and Investment Network. We'll be hearing from Yuan about her thoughts about the WHO pandemic treaty and intellectual property and access to medicines. Then we'll have some questions and answers from the audience. And then towards the end, Pat Ranald will wrap up with some concluding comments. We'll be recording tonight's webinar, and we'll make the link available to those who've registered afterwards. And the recording will also be available through the World Federation of Public Health Associations, through the Public Health Association of Australia, and through the AFTINET website as well. So just before we get further in, I'd like to acknowledge the traditional owners of the land on which I'm sitting tonight, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, past, present, and emerging. So our special guest tonight is Yuan Qiong, and she is a legal and policy advisor at MSF, and previously was the interim policy coordinator for the Access campaign for MSF. She's a licensed lawyer and researcher affiliated with the Law Development and Environment Research Centre at the School of Oriental and African Studies at the University of London. And her main expertise looks at the intersections between intellectual property, human rights, and access to medicines. She's taught intellectual property law, technology transfer, and international law, and has published several books on these topics. So she's a very, has a great deal of expertise in these issues. She has a PhD in law from the University of London, a Master of Philosophy in the Theory and Practice of Human Rights, and legal qualifications as well. So thank you so much for joining us tonight, Yuan. I'm wondering if, to start us off, you could tell us a bit about the history of MSF's concerns about equitable access to medicines. And I understand this goes quite a long way back to the HIV epidemic in the 1990s. And tell us a little bit about your role in addressing these issues.
Thank you very much, Deborah and Patricia. Can you hear me well at this
Yes,
stage?
thank you.
Thank you. Thank you, everyone, for the time. It's my pleasure to join the discussion today. Indeed, Deborah, MSF is working as an international humanitarian organization. We offer healthcare and assistance to people suffer from conflict and other epidemics and disasters in more than 70 countries in the world independently. So the reason as a medical organization that MSF has started paid attention and started working on intellectual properties and access to medicines is really dated back since the HIV epidemic, when MSF doctors working in developing countries witnessed the huge discrepancy between what's available in other parts of the world when more optimal treatments were made available, whereas in resource-limited settings and among communities in developing countries, those treatments were either not available at all, without registration, without any actions from company to market those drugs in countries where we work, or they were too expensive, mostly due to monopolies supported by intellectual property, mostly patents. or sometimes when diseases affect disadvantaged population the most, when they do not represent lucrative market, there were also very low level of interest to invest for R&D, research and development, so more appropriate medicine can be developed. So based on those observations, MSF established the kind of global program, Access Campaign, where I'm working now since 1999. Right after the organization was awarded the Nobel Peace Prize. So the mission of Access Campaign includes really to tackle those issues that MSF is facing on day-to-day basis in MSF medical operation, when medical products is facing kind of challenges to reach people who need it. But we also work a lot to analyze laws and policies around the specific access challenges to advocate and pursue long-lasting changes at national and international levels. The following some of the international negotiation is part of current mandate as well.
Thanks very much, Yuan, for sharing that information with us. So there's quite a few parallels really between the HIV epidemic and the battles to get affordable HIV treatments to people in Africa, and then what happened during the COVID-19 pandemic, aren't there? Do you want to tell us a little bit about that and some of the inequities that we saw in access during COVID-19?
Yes, I'm happy to do so. So as part of my work and our team's work, as I said, we follow what's going on in terms of access challenges, analyzing what kind of barriers related to specific products and also the systemic barriers around them. So we see a lot of similarities between what happened in COVID and what we have been working on since HIV epidemics, but also other outbreaks. MSF has worked on other disease areas, including hepatitis C, TB, and other regional outbreaks, such as Ebola and others. So we see what happened in COVID in terms of inequity in access is really a demonstration of many of the long-lasting issues that were not solved in the past decade, including one of the very prominent issues is intellectual property and technology monopoly. When life-saving medicines were developed, sometimes with a significant public support, be it funding support, policy support, or participation by community and patients. With all of this support, the system now allows a few pharmaceutical companies to claim the ultimate ownership on the medicines and technologies, which give them decision-making power to determine where and how the production should be organized, who gets what first and at what price. So that is a phenomena that's already manifested in other disease areas, but also happened during COVID. Even COVID pandemic is such a global scale kind of pandemic hitting every single country almost in the world. The monopoly power held by a few companies really hindered the rapid access to all medical products needed to control the pandemic in the equitable, timely, affordable, and sufficient manner. Because of this, is one of the major hindrance in the pandemic. It also gives kind of contributed other level of inequity issue as we see. For instance, we know in at the early stage of the pandemic, particularly a few countries with more resources and purchasing power also kind of purchased and stockpiled excessive amount of product for their own population, and those products were already in a shortage of supply globally. So without actually mechanism to be able to quickly ramping up the production, allowing more producers in other parts of the world to produce, and the supply, the shortage of supply was not really solved. And then, national stockpiling sometimes overtakes the global needs. And at the same time, corporation control the technologies. So those issues kind of brought us into a very unfortunate situation of inequity when many communities that we work, and in many countries we work, we see a delayed access to vaccines, and we see also a delayed and unaffordable access to therapeutics, and not very justifiable distribution, lacking priority setting, and lacking mechanism to pay attention to address the special health needs in humanitarian settings. For instance, we also, MSF also witnessed a very concrete example how the global response mechanism represented by COVAX facility for vaccines did not really work for us when there was only aftermath arrangement to cover humanitarian needs, whereas the humanitarian buffer didn't really work out quickly due to multiple reasons, including how the accountability of corporation was not checked properly. So I'll stop here, but we can go deeper. Yeah.
Yeah, I think you've touched on some of the really key issues there, including, the fact that the pharmaceutical companies were really the ones that were, in control of who received what products and when, and that stockpiling by the developed countries of the products at the end of that process as well. So really those monopolies that you were talking about, that the pharmaceutical companies had over the products are underpinned by intellectual property, aren't they? So while there are a lot of different barriers to access to pandemic-related medicines, intellectual property is one of the key barriers. And part of the backdrop to what's happening now with the negotiations around the pandemic treaty at the World Health Organization, which we'll be talking about in a few minutes, is the battle that's taken place over the last few years at the World Trade Organization about a proposed waiver for certain provisions in the World Trade Organization's TRIPS agreement for intellectual property rights for COVID-19 products. So this was a temporary waiver that India and South Africa proposed at the World Trade Organization back in 2020. And after many months of negotiations, I think it was 20 months of negotiations, there was finally an agreement to just very slightly tweak the rules that are contained in the TRIPS agreement to make it a little bit easier to export vaccines, COVID-19 vaccines from one country, developing country, to another. But it was a very disappointing outcome for MSF, I know, for AFTINET, for a lot of organisations that are engaged in advocacy in this space. And after that agreement, that very narrow agreement was made for vaccines, there were also efforts to extend that to cover medicines, so therapeutics and diagnostics. But those efforts basically stalled and have now been abandoned, haven't they? So Yuan, could you tell us a little bit about what that original temporary proposed, what we call the TRIPS waiver, so a waiver of some of the rules in the TRIPS agreement, would have meant for access to medicines, and what's been the impact, if any, of what we've ended up with out of that process?
Yes, happy to talk about that because we spent a lot of time working on that campaign. Indeed, it's really disappointed outcome for us after the MC12 decision was made. Compared to the original waiver proposal, which in MSF's opinion could have offered a much quicker and appropriate and really practical option for the pandemic response during COVID, because the waiver proposal, as the original suggested, envisage a situation whereby, as you rightly mentioned, Deborah, certain provisions and the TRIPS agreement can be temporarily putting aside, meaning country don't have to during pandemic to implement those provisions, which could facilitate a rapid overcoming of some of those monopoly barriers created by patent and other type of technology IP related to essential technologies. We think this is an adequate mechanism, particularly in a global health emergency situation when rapid access to technology and rapid coming up with alternative production and supply are so critical. And that could have led us to be less dependent on a handful of pharmaceutical companies' decision-making and goodwill. And for more particularly developing country government to mobilize their local industry to both produce for the local need, but also help each other when they cannot compete in the global market when the supply were in shortage. We also think that the waiver proposal could have mitigated some of the long-standing shortcomings of the existing TRIPS agreement rules, particularly compulsory license for exportation, which was one of the outcome following in the Doha Declaration of TRIPS and Public Health, but ended up with a very cumbersome procedure that was not fit for the purpose in an emergency. It also mitigated the shortcoming for each country to take their individual actions at a national level. For instance, during COVID, we did see some countries did issue compulsory license on particular products, but it did not. So those individual actions were really legitimate and very, helpful, but individual actions did not really contribute to overcoming the IP barrier across the supply chain, which require a more global action and collaborative approach of addressing IP barrier, which we think that the waiver proposal could have done that. But the actual outcome was really disappointing when only a procedural aspect of a compulsory license for exportation was addressed, and it only applies to vaccines. It is also not universally applicable. So for us, it's actually, if we put in the decision in a historical perspective, it's a huge drawback compared to what WTO member were able to achieve during HIV/AIDS epidemic, when the Doha Declaration was agreed and when certain waiver was granted at that time. with universal coverage. So all of the WTO members were eligible to use that. And also the decision back during the HIV/AIDS period of time was not restricted to any type of product. It covers all medicines. So the TRIPS decision, MC12 decision on TRIPS agreement only applicable for developing country member of WTO, except China. So it did not apply to high income members of WTO, which we think is it's really a pity because many high income countries also had access issues during COVID. It's not like every single country were better off, and some country could have contributed in global production with their local industry. It only applies to vaccines when we were actually facing access challenges on therapeutics and diagnostics as well due to IP issues. For instance, we heard a lot of arguments by the industry in the TRIPS waiver during the TRIPS waiver discussion that voluntary action, voluntary license should be the way to go. But what we see is during COVID, there was only 3 licenses offered to Medicines patent pool by the pharmaceutical company, and none of the license were ideal actually. So none of the license reached the coverage that should have been reached during the pandemic. And Pfizer and others also hold monopoly in many middle-income countries, didn't allow them to produce. So we think it was a really a missed opportunity to set up a positive precedent during COVID pandemic, how IP issues should have been dealt with in facing global health challenges. Of course, with the later abundant, as Deborah you mentioned, after such a long time negotiation, WTO process eventually abandoned the extension discussion to extend the decision to diagnostic and therapeutics. We think it's really a lessons learned to be learned in the current pandemic treaty negotiations.
Thanks, Yuan. And I think that, that's a really interesting point that you made, that it's not just, the implications are not just for COVID-19, but the implications of that disappointing outcome from those negotiations at the WTO is also that it sets a terrible precedent for future pandemics. So even, in this terrible 1 in 100-year pandemic, countries could not come together and agree in several years of negotiations to waive those rules just for COVID-19 products. And that's really where the pandemic treaty comes in, isn't it? So can you tell us a little bit about the impetus for developing a pandemic treaty or agreement at the WHO? What was seen as important by organisations like MSF and by developing countries in terms of achieving through that agreement?
Yeah, thanks. Indeed. So the current negotiation has been seen as a very important norm-setting process at the international level. We understood the original ambition as expressed by many WHO member states and WHO Secretariat, who's organizing this negotiation now, was really to find a way to break from the status quo as everybody experienced during COVID, to have a different way of governance and accountability mechanism so that the future pandemic can be managed and prepared for better, particularly to address some of the inequity we experience in pandemic. So for MSF, we see this as a opportunity to realize and reflect the lessons learned from pandemic of COVID, but also from other outbreaks, as we see the the cumulative effect of many unsolved access and equity issues from other outbreaks, so that the future global mechanism and state obligation could be clarified. So there are quite a few issues. If we see this could be opportunity to support equity in the future, there's quite a few issues we think are important and that may need to come together as a package in order to make sure the effectiveness of the final agreement, which should give a clear framework to guide what's the responsibility of governments are in the future pandemic governance, including so those important issues, including first, intellectual property issues need to be addressed in this agreement. And many opponents argue that, the WHO is not the right forum to address IP issues because we have WTO, we have World Intellectual Property Organization, and intellectual property belong to those organizations. And we think this is wrong because WHO has been dealing with IP issues for quite a long time. And the treaties and agreements under WTO and WIPO have different objectives to fulfill. And protecting health is not really their main objective. And well as WHO has the duty to promote and protect the right to health as embedded in its constitution. And all of the WHO member states will abide by this duty to protect health. So under this, in light of these objectives, it is the right forum to address IP issues, which has been, as we know, demonstrated as one of the key barriers to issue access and equity. So IP issues need to be addressed here. We hope, as MSF, our position is at a global level. There should be a recognition of the importance of using different mechanisms such as waivers at national level, suspension of the enforcement of IP, but at the national level, countries also need to review and update their national laws to make sure they have the full package of flexibility that they can use. Countries should also respect each other when it's come to using flexibility for health and refrain from putting pressure to each other, especially during emergency, when IP measures are to be adapted. At the same time, we also see there's cross-cutting issues related to IP, but also beyond. For instance, in COVID and in other outbreaks, pharmaceutical company maintain a monopoly, but most important research and developments were funded by public investment from different government and philanthropy donors. It has been a pity that most of those funding agreements did not come with conditions to request company to behave so that global access can be secured. We think the agreement here is also an opportunity to make a straightforward obligation and establish norms so that public investment on research and development should come up with very clear conditions, including requirements for sharing intellectual property and know-how. There's also the third very important component for equity is to establish a global mechanism for access and benefit sharing, which we know some civil society organizations have more expertise and followed on. This is a very important step for us to realize that community and developing countries and normal people contributed to research and development by sharing their samples and pathogens to support product development. But oftentimes the global norm on access benefit sharing did not play out because there was no established mechanism to govern those sharing so that when countries share pathogens, they could anticipate a benefit coming back so that the global needs can be covered. So a very effective and a binding mechanism for global pandemic pathogen sharing and access and benefit sharing mechanism will be key. We also think it's an opportunity to address the transparency issue across the actions of R&D funding, procurement, and stockpiling allocation. During COVID, we also see many secrecy was claimed by company when public procurement agreement were not made publicly available. Many civil society was trying to follow up what their government has been doing, and without much success, because confidentiality claim was used very ultimately across different countries. We think pandemic treaty is an opportunity to also make it straightforward rule to make sure there's a decent transparency, accountability across different provisions. Yeah, so I'll stop here. Probably one last word as MSF, as humanitarian organization. We also hope there is a sufficient recognition of the special needs for people living in conflict and the respect of humanitarian law as a bottom line for the negotiation. Yeah.
Mm. Thank you very much, Yuan. So, I mean, you've covered a lot of issues there that are really important in terms of making sure that the outcomes are really different for people living in developing countries in future pandemics, and that we don't see the same mistakes made as during COVID-19. And I remember when I saw, you know, early drafts of the pandemic treaty text, that it was quite exciting to see a lot of these things that you're talking about actually featuring in the text. And I think a lot of people were you know, very hopeful that this would make a real difference in the future. But now we're a few years into the negotiations now, and we're coming up to the deadline that countries set for themselves of the World Health Assembly in May. So the 27th of May, only a month and a half away now. But the countries are still quite far apart on the key issues, aren't they? And things haven't progressed as far as we'd like. And we've also seen the text watered down quite significantly from what was originally proposed in some areas. Can you give us a bit of an overview of where things are up to at the moment, what's happening in the negotiations, and what the key issues, what the key opportunities and risks are at the moment?
Yeah, thank you. Yeah, so I will try to share what we have observed from MSF when we try to follow the negotiation closely. I will also later share some resources of our analysis for reference. But yeah, as you rightly pointed out, Deborah, many of these key issues, as we just mentioned, were still are still very contentious in the negotiation. We see some minor progress on some of those issues. For instance, when it's come to include access provisions in public funding agreement, we saw some progress in the recent text when explicit example were given when there were, of course there were better texts in an earlier draft, but it was lost, and now it came back a little bit. But overall, the obligation has become a little bit weaker. So it seems to us there's overall phenomena among negotiating parties that there's reluctant for government to really take a very hard obligation at this stage of negotiation, which we find is a pity, because the value of having international treaty is really to show a commitment that some of the national practice and law need to be changed in order to have a new way of governance at a global level. But if national government want to reserve what they have now, and we may not have a vision that the status quo can be changed. So public funding condition is an area we see one step forward, but then two steps backwards in terms of obligation. But of course, as you mentioned, there's still time. There's still the last round of negotiation. The time is ticking. At the end of April, there will be the last round of negotiation. If countries really want to make things right, they still have time, the last moment, to make it right, so we can have a strong commitment. IT issues is very contentious. We know waivers discussion is a red light for many high-income countries. They don't want to even engage that discussion. So we saw some a good text in a early draft, for instance, commitment that the country will not impose TRIPS plus provisions to each other when they engage bilateral or trade negotiations. Those texts are now gone, which we find is a pity because it's a realistic challenge facing many developing countries now. MSF and many others now, we are still working to resist TRIPS plus provisions in ongoing trade negotiations. But of course, we're happy to see TRIPS flexibility clauses remains, but we know there's a dispute to return the tax of respect each other, which we find is very unfortunate because that could have been an easy political commitment to put in agreement to say not only recognize there's already existing flexibility, but countries should respect each other because we already saw a lot of disrespect in the past. Those issues remain undetermined. The negotiation for a global pathogen access benefit sharing mechanism is pending because key issues are not solved between the negotiating parties, particularly in terms of how strong the legal obligation the agreement could deliver to bind pharmaceutical companies when they want to use pathogens shared through the mechanism, and how strong the obligation can be is also in the discretion of national government who are engaged in the negotiation. So we see some progress, but many key issues are still very contentious.
Thanks, Yuan. I'll ask you a little bit more about TRIPS flexibilities in a moment, but just wanted to point out to people we will be moving on to questions from the audience in a moment. So please do post your questions in the Q&A if you have a question for Yuan. So just on the issue of TRIPS flexibilities, you've spoken a little bit about that already, Yuan. I was just having a look at the most recent draft of the pandemic treaty text from the end of the negotiations, and there's quite a few interesting things there. So I noticed that the proposal for a waiver, time-limited waivers for intellectual property rights is it still appears in the text as it currently is at the moment. We know that's a very contentious issue that many of the developed countries are saying they're not going to agree to, and it may not end up in the final text. But there's also some provisions that require countries to respect the use of TRIPS flexibilities by other WTO members, and a requirement for countries to review and update their national legislation to implement the TRIPS flexibilities, which are really important and positive steps, aren't they, if countries agree to include those in the negotiations. So can you just tell us just for a moment or two why that's so important? Why do we need to have something in there about TRIPS flexibilities that goes beyond what countries are already able to do?
Yeah, Yeah, I'm happy to. So I will also share one of our papers later for later reference. Because indeed, TRIPS flexibility has been there for more than 20 years. But we see a lot of, and it's being referred and reaffirmed, cited by dozens of international instruments, including many WHO, the World Health Assembly resolutions. Multiple resolutions have reaffirmed the existing flexibility country already have under TRIPS agreement. And the Human Rights Council document resolution also referred to TRIPS agreement, TRIPS flexibility when it's come to the discussion of access to medicine and right to health. But why do we still need to have something here and also go beyond? Is particularly because after this multiple reaffirmation reference to encourage and remind the country you have these flexibilities, we still see ongoing challenges to fully realize and use those flexibilities in reality to address access to medicine challenges due to multiple reasons. One is there's ongoing unilateral, bilateral pressures being it from political pressure, trading pressure, commercial pressure to discourage developing countries to use the flexibilities, and also to discourage and lacking support to country to really incorporate those flexibility into national law based on their context to maximize the legal effects of the flexibility at national level. So those pressures coming from, for instance, U.S. trade representative, a European Union trade report, and so on, are an ongoing challenge that hasn't been addressed. And those challenges, secondly, those challenges also reflected in bilateral and regional trade agreement and investment treaties when more requirements for protecting IP were put forward, go beyond the TRIPS agreement requirements, and some of those provisions also go against TRIPS flexibilities. So when you have flexibility and you agreed on something else, and the trade agreement is kind of contradict to each other at a national level. Those challenges we think have not been, and could not be addressed properly in WTO and WIPO, because there is no existing international law in WTO law and WIPO treaty to check those TRIPS plus provisions and to see, okay, at the national level, what kind of obligation and responsibility national government have to actually implement flexibilities, because it was presented as a passive right. So you have the right, but you don't have to use it. You can put that, you can see I have the right, you can see you have the right all the time, but there was other obligation, other action to undermine those rights. There's no mechanism to check those undermining actions. So therefore, we think a pandemic treaty negotiation is something different, because the purpose of pandemic treaty negotiation is not to protect IP. So promote free trade and promote IP is not an obligation of WHO, which are obligation for WIPO and WTO, whereas WHO has obligation to protect health. So we think this is the right forum to looking things around to say, in order to protect access to pandemic products, access to medicines, in order to protect health, the country actually have obligation to use flexibility as a means to achieve that goal. So we think something beyond just reaffirm you have the right or to do a flexibility is absolutely important. So that's back to what you mentioned, Deborah, the language of respecting each other's use, and as a minimum, because we actually want something stronger to see there's an obligation to actually use it in order to achieve some pandemic treaty objective. But at a minimum level, respect each other to use and also make sure national law are ready to use those flexibility is something really important to go beyond just reaffirm the rights.
Thanks very much for explaining that for us, Yuan. So I've just got one more question for you before we move to the audience questions. And that is, I'm just wondering if you have any comments about the role that Australia and other countries like Australia can play in the negotiations in terms of trying to get an agreement, first of all, and get an agreement that really does help to promote access to pandemic-related products for developing countries.
Yeah, thanks. Yeah, we think Australia is can play a very important role. So far, Australia has been facilitating some of the thematic discussions in like very important areas of work on access, benefit sharing, and so on. We hope it could hold a strong position supporting the equity clauses by particularly if we talk about IP issues. So following our discussion just now in terms of TRIPS flexibilities and supporting each other to use the full extent of flexibilities, updating national laws and so on, we think Australia can play a very positive role, particularly to realize that Australia may also need to look at its national law to update it. And we know during COVID, some similar action actually happened in Australia when national measure on compulsory license were looked at. So we think to reflect those areas as a common challenge, no matter what kind of income category country are sitting in, access to medicines is about people. It's less about competitiveness in the global market. It's about Ministry of Health taking their responsibility to make sure everybody in their jurisdiction and in their neighboring countries are taken care of, are having the access to life-saving medicines. So we think Australia should also play this role and respect, kind of showing the commitment and solidarity by supporting at least, some of the clauses we mentioned on related to IP. We hope Australia could play a role showing the commitment can come from high-income countries for the global solidarity purposes.
Thank you very much, Yuan. So I'll now go to some questions from the audience. So the first question is, how can we strengthen the financing of international procurement instruments like the Global Fund or Gavi or similar efforts to ensure equitable distribution? And what's the role of the pandemic treaty in I guess that distribution of products?
So in terms of international procurement mechanism like Global Fund, Gavi, and also many of these institutions were also part of the AFTINET initiative during COVID. We think that there's a few things need to be changed actually to make sure the future mechanism will be more effective. One is the governance issue related to these global health institutions. So far, we know nearly all of them were governed by their own governance structure. When many of like Gavi and Global Fund, when they became part of the global pandemic response mechanism under ACT-A, they will not really report to a multilateral mechanism governed by WHO member states and properly oversight by civil society and general public. So the governance structure need to be changed in order to make sure these institutions will be more accountable when they were tasked to procure and deliver for global response. They need to be properly oversight governed, and there has to be a greater transparency requirement. For instance, we know Gavi is leading the COVAX pillar and Act A for vaccine procurement and distribution. We actually don't really know what kind of procurement negotiation Gavi had engaged because the agreement were not very transparent. We didn't know, in terms of IT licensing, pricing, distribution, what the company has asked Gavi to agree on. And because all of those key information were under confidentiality claim, which hinders the accountability of the organization to really report back to public and government who put money on their operation, what they actually performed. So transparency was absolutely important to ensure accountability. And also when it's come to distribution, we think that there's a lot of lessons learned from particularly COVID when the distribution and equitable allocation were not really done, particularly in the early stage, with properly and pre-agreed criteria that we can also check back. Because I mean, one example, as I mentioned, is a humanitarian buffer and the COVAX facility to cover some of unmet health needs in humanitarian settings. Those mechanisms were not established from the beginning of the global response. It was after the inequity already occurred. So some institution, institution realize, oh, by the way, we also need to cover humanitarian needs. Let's get some special mechanism later on. But because that was not properly planned in advance from the very beginning and properly governed, for MSF, for instance, we actually tried to withdraw vaccine from that special mechanism. We couldn't after long time of effort because the mechanism did not come with an easy to use procedure. We had to renegotiate with institutions and with companies to make sure the doses were we can deploy and withdraw very quickly. So those distribution strategy need to, if in the future pandemic instrument agreed with a similar setup or a different kind of setup for global distribution, some of those key lessons need to be reflected and mechanism need to be agreed from very beginning rather than late.
Thank you. Very good points, Yuan. So another question is about the trilateral cooperation between the WTO, WIPO, and the World Health Organization. So would you like to comment at all on whether there are any leadership tensions underlying that cooperation and how that might affect the governance of these types of issues and how that might play out in the pandemic treaty?
Yeah. So yeah, indeed, we think the trilateral collaboration between WTO, IPO, and WHO should not be used as an excuse to say that WHO cannot deal with IP issues. So that's for us is a starting point to clarify. Of course, when it's come to very technical issues, maybe WIPO and WTO have some resources that can be helpful, but it's important in our opinion that to clarify two things. First, what is the objective? What is the ultimate objective of this collaboration in the context of access to medicines and public health? If the ultimate objective is to say IP needs to be dealt with and managed in a way to be more supportive to access to medicine and protecting our public health, and then WHO's leadership has to be returned and has to be strengthened and recognized in that sense, because the technical support from WTO and WIPO should be more supportive rather than overtaking the leadership of WHO, whose main mandate is to protect public health and ensure access to medicines. Of course, you know, if the things are another way around, to say the objective of the collaboration is to strengthen international IP system, then maybe, you know, WIPO should take the lead, which we don't think is a point for this collaboration. So the collaboration should clarify the technical expertise of WIPO and WTO should be supportive to the achievement of the access to medicines. However, we do acknowledge, you know, the current discussion in the pandemic treaty did reflect some of this struggle and debate who's leading what in terms of IP. But some, you know, we hope clauses like TRIPS flexibility respecting each other, if retention of those texts would reaffirm WHO is the right forum to address those issues.
Thanks very much, Yuan. So I'll now invite Dr. Patricia Ranald to make some concluding comments, and then we'll wind up the webinar. And I apologise that we weren't able to get to all of the audience questions tonight. Thank you, Pat.
Thanks very much. For those who don't know me, I'm the convener of the Australian Fair Trade and Investment Network, which is a network of community organisations advocating for trade justice in Australia and globally. And I'm also an Honorary Research Associate at the University of Sydney. I want to thank both of our speakers for a very stimulating discussion. We were very lucky to have two such distinguished panellists. MSF Medicines Access Campaign work has informed my own trade justice work for many years, beginning with those early debates about the WTO TRIPS agreement and TRIPS flexibilities, and through more recent campaigns to oppose TRIPS plus provisions, that is, even more strict, restrictive intellectual property limits on medicines in agreements like the Trans-Pacific Partnership and the Regional Comprehensive Economic Partnership. So MSF has really played a huge leadership role in these debates and in actually helping to keep some of those restrictive provisions out of those trade agreements, or at least reduce them in some ways. And of course, Deborah Gleeson is a leading expert on trade agreements and public health, both in Australia and globally. And I think together their discussion has emphasised very clearly the power exercised by the global pharmaceutical industries, supported by their governments in high-income countries, which has so far proved a barrier to equitable access to pandemic-related products in low-income and middle-income countries, resulting, we shouldn't forget, in the loss of millions of lives during the COVID pandemic. So as we approach the final stages of negotiations for the World Health Organization agreement for future pandemics, we have to bear in mind, as Yuan said, that the major objective is public health, improving public health and improving access to medicines. And we are advocating to the Australian government to support the demands of those countries for a series of proposals which have been raised by our speakers, which would hopefully avoid the mistakes of the COVID-19 pandemic and result in meaningful obligations, real obligations on government to ensure equitable access to pandemic-related products. And I'd like to finish by thanking Leanne Coombe from the Public Health Association of Australia and Hope de Roy Underhill from AFTINET for organising this webinar, and thanking everybody who's attended and participated. So thanks very much and enjoy the rest of your day.
Thank you very much to both Yuan and Pat, and thank you to all the audience members who joined us tonight. We'll conclude the webinar now.